This video will explain how the process works. When someone like you hires us, we show up to that magistrate hearing on your behalf. We specifically ask that our clients do not attend the hearing because we need to defend the case based on a lack of evidence and win it on a technicality. Now, under the law, you have the right to send an attorney in your place, and that's because you're the defendant in a civil case. You have nothing to prove, and your creditor has everything to prove. It's solely their burden. Now, if you were to be present, then your creditor would have the right to cross-examine you. And then your testimony, no matter what you would say, would technically be evidence that goes towards meeting their burden. And that's what we want to prevent. That's why we don't want you there. Now, without you there, we have strategically left their lawyer with only one other means to prove their case. And sure enough, your creditor is going to come with copies of the credit card agreement and copies of the monthly statements. And they need to show that to the judge as their evidence that you owe a balance. But it's at that point that as your attorney, we're going to object. We're going to stand up and stop the court proceedings. And what we're doing is making a hearsay objection. Generally speaking, the judge knows that these types of documents created by a bank outside of court back in time and perhaps sold to a third party, these types of documents are hearsay. And hearsay is inadmissible in a courtroom. You can't use it unless the proponent of the evidence can authenticate those documents as a business record. Now, authentication is a legal term with a very specific meaning. But to put it simply for you, all of the information and data needed to authenticate those documents, it did exist, and it was available to your creditor when they purchased your debt, and they choose not to buy it. They don't buy it because if they get all that additional information and the rights to communicate with the original bank, it makes the account several times more expensive to purchase. Still affordable, mind you, because we're only talking about pennies on the dollar. But your creditor knows that the losses in court for doing business this way are minuscule in comparison to that upfront cost savings. In other words, they don't care that they're going to lose 1% of their cases because they're making 10 times the amount of money by cutting these corners and doing business this way. So they're purely motivated by money. Now, their motivations are not actually relevant, so they're not often discussed in court. The only thing that matters is, what does the law say? And the law is very clear on this subject, and it's on our side. And the court's job is to follow the law as it's written. So the judge is going to sustain the objection, and once that happens, it's a death blow to their case, because the court will not consider or view those documents in making its decision. Furthermore, your creditor doesn't have a witness that's competent to testify without the use of those documents, so they can't even take the stand, and then you're not there to be cross-examined. So from a technical standpoint, the court doesn't have any evidence to review whatsoever. Your creditor fails to prove anything, and so their case has to fail. The judge must decide the case at the conclusion of the hearing, and there's only one decision the court can make in that circumstance, and that's a ruling in your favor. So we get judgment for defendant, and that is a legal decree that says that there is no debt. The debt is in fact extinguished. It no longer exists. Your creditor loses 100% of their rights. That means they can no longer call you, they can't send you letters, they cannot sell the account, and they can never sue you. More importantly, they lose their right to appear on your credit report. And in the next video, we'll discuss how your credit is repaired.